Yes, so we are continuing our discussion of the types of debentures, having already noted that one way of classifying debentures is to look at in terms of the duration within which the debenture may be redeemed, that is paid back by the company. So last meeting, we noted that in terms of Section 87, it is permissible to have a perpetual debenture. Perpetual debenture is a debenture which is such that its redemption is premised upon the happening of a contingency, that is an event, which may be so remote that is to say that that event is not likely to occur, if you like, anytime soon. So, for example, if you say that the debenture will be redeemable when Ghana has the 25th president of the Fourth Republic. Now, if you look at our country, I think the current president, Nana Dankwa Akufo-Addo, is I think it's the fifth. The first was President J.J. Rawlings, President Kufuor, President Atamas, President Mahama, President Akufo-Addo. Good. So if you say that the debenture being created will be redeemable, that is to say that the company will have to fully pay back the money and everything when Ghana swears into office its 25th president of the Fourth Republic. So that is a contingency. When Ghana has sworn its 25th president of the Fourth Republic into office, then the company will have to redeem, will have to pay back the money, which is represented by the debenture to the debenture holder. But if you look at it, you notice that this contingency is very remote, 25th president. So on average, if a president is doing 8 years, we now have the 5th president. So 20 more president, you multiply that by 8. So that is a long time. And there are a lot of things which can happen within that period. And so that could be, if you like, a typical example of perpetual debenture. Then we also have the convertible debenture, as we have explained, meaning that a debenture that you can convert to become a share on the terms that will have been stated in the debentures at the time that it was created. So tonight, we want to concentrate mainly on secured and unsecured debentures. And actually, this is the heart of debentures when you are discussing debentures as a topic in corporate finance in company law. So we need to pay attention and understand properly. Yeah, so what is a secured debenture and what is an unsecured debenture? We understand that a debenture is a loan, is a debt. Evidence in writing by the company. The company has taken a loan from someone, from a lender or creditor, as it were. Now, from the point of view of the creditor, the lender, or the debenture holder, you are going to give a loan to the company, you will definitely be concerned about the ability of the company to pay back the loan, the ability of the company to redeem the debenture for you when time is due or time is ripe for the debenture to be redeemed. So that is one concern. And related to that concern is another concern that where it happens that you are not the only one who has lent money to the company. Others too may come and lend money to the company, or the company variously may become indebted to those other persons or entities. And should it happen that the company has fallen on bad times, is not able to pay its debts and liabilities, so that the company is put on the path of official liquidation, is being liquidated, is being compelled to fold up. So when it happens that way, there will be rush for the assets of the company. The assets of the company may not be enough, because to start with, if the company had enough money, if the company was, had the capacity to pay its debts and liabilities, it will not have had to actually be put on the path of compulsory liquidation, as it were, official liquidation. So there is something wrong in terms of the assets and liquidity position of the company. So people will be rushing. So if you are a rational lender, you are going to take a debenture, you are going to lend money to the company. You may have to ponder all these issues and all these possibilities. And because of that, it may lead you to do one of two main things: either to impose high interest rates because of the high risk associated with the lending that you are providing to the company through the debenture, or you may want to extract security from the company. The company should provide something as a security, which would protect your interests in the event that the company defaults or the company is being liquidated. So that is the general background I want you to have. So let's look at the law now. Section 89. Subsection 1 says, debentures may either be secured by a charge over the property of the company, or may be unsecured by a charge. So we are told that a debenture may be secured or unsecured. And it is secured where it is secured by a charge over the property of the company. A charge is an encumbrance, as you remember your law on mortgages, as it were. So where the company has encumbered its property or its assets as a means of securing a loan which it has been given, then we have a secured debenture. Now, in terms of secured debentures, we have two categories. Secured debentures may be further divided into two. where the debenture is secured by a fixed charge and where it is secured by a floating charge. So therefore, Section 89(2) will tell us that debentures may be secured by a fixed charge on some property of the company or a floating charge over the whole or a specified part of the undertaking and assets of the company, or by both a fixed charge on the property and a floating charge. So first and foremost, what is a fixed charge? A fixed charge is where the security is created over a specified assets of the company. And before we discuss that further, as I have told you before, anytime you are reading any law, any legislation or enactment, and you come across a word which is not a normal like English word, and it is legalese, you quickly need to move to the interpretation section to get the meaning. So if you go to Schedule 1, of the interpretation the interpretation session, or the Schedule 1, charge is defined as this. You can just jump to your first schedule at page 302. Charge includes a security on property or a mortgage, whether legal or equitable statement, to the effect that it is true and complete copy of the original or an accurate translation of the original under the seal of the company or signed by the director and company secretary. So the basic point is that a charge is an encumbrance on the assets of the company. And this encumbrance may be a fixed, in which case we have like a fixed charge. And as I said, that means that the security is over a particular or specified assets of the company. So you can have a charge over maybe the plants and machinery of the company, or you can have a charge over the buildings of the company, or any particular asset of the company. You can have a charge over that. So where that is the case, then your charge is said to be a fixed charge. Now, because it is a fixed charge, what it means is that there is a limitation on what the company can do as far as that asset is concerned. The company cannot dispose of it. The company cannot use it to do any credit arrangement again until the obligation underlying that particular security arrangement or that charge is satisfied by the company. And then it is released from that encumbrance. So that is a fixed charge. Then we also have a floating charge, as also been mentioned. We'll be discussing a lot about it pretty soon. So floating charge is a charge which is not premised upon any particular asset of the company. So let's keep that in mind. So floating charge is not in relation to any particular assets of the company. And it's a charge which is created over either the whole of the operations of the company, undertaking of the company, or the whole of the assets of the company. So therefore, that charge is said to be ambulatory. Ambulatory in the sense that, for example, if the company is, let's say a company like, let's say a company in any manufacturing business. Let's say manufacturing Ghana. Let's take any of the alcoholic beverages production companies. Maybe you take either Casa Precon or you take Angel or whatever. So you have a charge over, let's say that the undertaking, that is the whole of the operational aspects of that company. The machines, the things being produced, the things in the warehouse and all that, they're all part of the undertaking. Now, as it is, we do not know any particular asset in respect of which your security is premised upon. And it will remain like that until circumstances have arisen for the security or the charge become enforceable before the charge or the security will fasten onto particular assets of the company. So that is the floating charge. That's why the word floating. When floating, a cotton. How cotton is floating in the wind, as it were. It hovers. It does not stand still. So the charge is actually hovering over entirety of the either the undertaking or class of assets of the company, as it were. And these words that I am using are words which actually emanated from a long line of jurisprudence under English company law. And the well-known one, the case of Ellensworth against Holsworth, Lord Magneton's famous dictum, which I'll quote for you. So let me put the case here. We have the case of Ellenworth against Holsworth. And 1004 AC 355. Now, in Ellenworth against Holsworth, Lord Magneton made an important statement, which actually, describes what a floating charge is, as distinguished from a fixed charge. So let me quote what Lord Magneton said in Ellenworth and Holsworth. Quote, "What I said, that is, in Manila Railway case, was intended as a description, not as a definition of a floating security. I should have thought there was not much difficulty in defining what a floating charge is, in contrast to what is called a specific charge. No, specific charge is the same as what as a fixed charge. I think is one that or that more fasten on ascertained and definite property capable of being ascertained and defined. So that is a fixed charge. Then a floating charge, on the other hand, is ambulatory and shifting in its nature, hovering over, and so to speak, floating with the property which it is intended to affect until some event occurs or some act is done, which causes it to settle and fasten on the subject of the charge within its reach and grasp, unquote. So Lord Magneton in Ellsworth against Bosworth is telling us that, yes, look, when you talk about fixed charge or specific charge, as he used the word, we are talking about the type of security which is over ascertained, that is a definite property. So we know the particular aspect of the property in respect of which the security relates. So that is the fixed charge. And as I said, it can even be like the lease. It can be the whole building of the company. Or the most important thing is that there is a identifiable, a known asset of the company in respect of which the charge or the security relate. So that is a fixed charge. And then he makes the point that when we are talking about floating charge, on the other hand, we have to remember that floating charge is ambulatory. Ambulatory, those of you who went to good schools like St. Hubert Seminary, you have learned Latin, and ambulatory comes from the Latin word ambulat. And ambulat, that is like to move. So that is where we have like the word ambulance, right? So ambulatory means that something to do with walking or movement. It doesn't stay still. It doesn't stand still. So the security is not fastened onto any definite assets. So we cannot pinpoint a particular asset of the company in respect of which the floating charge relates. So that is its nature. Fixed charge, on the other hand, we can pinpoint a particular asset of the company in respect of which the fixed charge relates. So let's keep that in mind. But then the floating charge, as I said, it will get to a stage, that is when we become enforceable or when circumstances are right, it will then become fastened onto particular assets of the company, and it will no longer be just hovering. It will have settled. So let us keep that in mind. Of course, in our own case of George Cohen, this definition was also adopted by our own High Court Judge Edusei. So in George Cohen, let me put it here, George Cohen. Cohen's West Africa Limited against Comet Construction. It was interpleader proceedings, so GCB was a claimant. So if we look at the 1966 Ghana Law Report, 777. At 779, His Lordship Edusei said this, and I quote, "A floating charge, which is quite distinct from a specific charge, does not fasten on indefinite property, but as an equitable charge on the property which is constantly changing. For example, stock in trade. However, if the debenture holder, on the happening of some event stated in the debenture, takes steps to have the floating charge crystallization, the charge then becomes specific or fixed charge, unquote. Now, there is a more recent case, and it's an English authority, which I would like all of you to read. And that has to do with the case of the Ray Spectrum Prax. Ray Spectrum Plus. The 2005 decision, not that really recent, but compared to the rest. So in Ray Spectrum Plus, for example, Lord Scott would further clarify the nature of floating charge in contradistinction to fixed charge. And this is how Lord Scott expressed himself, and I quote, "The essential feature of a floating charge, the characteristic that distinguishes it from a fixed charge, is that the asset subject to the charge is not finally appropriated as a security for the payment of the debt until the occurrence of some future event. In the meantime, the charger is let free to use the charge asset and to remove it from the security," unquote. Yeah, so if we piece all these dicta together, in the various cases that we have cited, what we are noting or witnessing is that as far as floating charge is concerned, because the security does not relate to any particular asset, the company has the freedom or the latitude, the autonomy to deal with those assets or to deal with those class of assets over which the floating charge hovers. However, with respect to fixed charge, the company does not have the freedom to deal with those assets anyhow. It will need permission of the charge holder, as it were. So let's keep that in mind. Now let's look at the text of the law to continue our discussion. So in terms of Section 89(3), a charge securing debentures becomes enforceable on the occurrence of the events specified in the debentures or the deed securing the debentures. So mind you, debenture is also a contract, it's an agreement. It's a special loan agreement or special credit agreement between the company and the debenture holder. So the terms will be spelled out. When the company is supposed to pay back, and then interest and all that. And again, where the debenture is supported by a security provided by the company, either a fixed charge or floating charge, the debenture will specify those events which will trigger or which will occasion enforcement of the debenture, so that the debenture holder will be able to go after particular assets of the company in order to realize whatever money the company owes him or her, as it were. Now, 89(4), where legal proceedings are brought by the debenture holder to enforce the security of a series of debentures of which that holder of which that holder holds part, the debenture holder shall sue in representative capacity, personally, and on behalf of the other debenture holders of that series. Yeah, so the point we are making is that we have already noted that debentures may be a standalone unit, right, in which only one person is the holder, or the company may create what we call debenture series, especially where a block loan is contemplated and the amount involved is so huge that the company cannot really wait to get a single debenture holder or just two to come and take the debenture to enable the company get the money that it needs. So the company may decide to break the huge money it needs down into smaller units and create one debenture and have the series within them, all at the same rate and maybe like the same maturity dates. So where that is the case, and it is also secured, it's secured either as a fixed charge or floating charge. Then section 89, subsection 4 is telling us that where there has been a default or where any of the events stated in the debenture any of the event has occurred so that it has become enforceable. Being enforceable means that you may have to go to court and get orders and all that. You don't go as just an individual if your debenture is part of a debenture series. You have to bring your enforcement action in representative capacity. And if you look at section 205, as we have referred some time ago, in a representative action, the outcome of the action will not only be for your benefit, but to be for benefit of all other debenture holders who are similarly situated like you. So if you mobilize them and they fund the litigation, that will be a good thing to do, because if you decide to go solo and you bear the cost, if you are successful, the benefits will not be available for you alone to enjoy. It will be available for all those who have similar complaints as you. So all those who have debenture within a debenture series, they will also enjoy the fruits of your victory if you are successful. So let's keep that in mind. Another point, which is really pertinent and we come back to it, is what we call registration of particulars of charges. So therefore, section 89.5 makes the point that where we have secured debentures, then the company must comply with registration requirements under section 110 to 121. We'll go and discuss that pretty soon after looking at the section 90. Now, the point to note is that the company is there, a public company, of course, always looking for money, and you have given money to the company, so you have a debenture holder. The company has used one of its assets as a security for you. Now, where you just keep this information to yourself, the company may use the same asset, which is used as a security for your loan, as a security for another loan from a different person. And the problem will become really felt when there is a default and all the people who have security against the company decide to go after the same asset. So to avoid all that, the registrar of companies is supposed to create what we call a registrar for registration of particulars of charges created by a company, so that anytime a company will create a charge, particulars will have to be submitted for registration by the registrar of companies. And that is a registry, registrar which is available to the whole world. Anybody at all can go and conduct a search to know the state of affairs as far as assets of the company are concerned, and if the company has used its assets to actually secure so many loans, then you know that there are many creditors who have interest in these assets. So I have to be careful not to allow the company to use the same assets to raise another loan from me. So that is why the registration of particulars is really important. But we will look at the details or the mechanics of it when we are discussing session 110 to 121. Now, Section 90 provides a more explicit definition of floating charge, as we have been discussing already. And as we go through, you notice that the statutory definition here is actually enactment of the ratio dissidenda of some of the old cases that we have seen, including the case of Ellingwood and Holsworth, and then the case of Ray Yorkshire Woolcombers Association, another old case which is whose ratio have been incorporated into the legislation. So if you look at Section 91, it reads, and I quote, subject to subsection, let me delete these annotations. Okay. Same time. I know. Yeah, so Section 91 is to the effect that subject to subsection 2, a floating charge is an equitable charge over the whole or a specified part of the undertaking and assets of the company, both present and future. Yeah, so we have already noted from the case law that floating charge is ambulatory. And ambulatory here is what is being referred to as the fact that the floating charge is an equitable charge. It has not actually settled on any particular assets. And that is why we say that it's equitable. And it can apply to current assets of the company and assets yet to be acquired. You can have a floating charge over the whole of the stock of a particular shop. So you take a shop like maybe Palace, right? Palace or Mecom. Let's say Mecom. Mecom is more common for a lot of Ghanaians. So take the case of the shop of Mecom, for example. let's say that they come and take a loan of 100 million Ghana cedis from about let's say about they've taken from a debenture, let's say a particular bank, which is like the debenture holder in respect of that loan. And they say that we are using the stocks of the shop, that is the things that we are selling, that is the stock, including things which are in our warehouse as the security for repayment of the 100 million loan or debenture that we have taken from you. Now, if you take the stocks keep changing because they'll finish selling them, then they will restock, finish, restock, finish, restock. If you also go to the warehouse, the things in the warehouse are not static. The things in the warehouse will keep changing. So that is another point to note. And that is why Section 91 is saying that the floating charge is actually over the whole or specified part of the undertaking and access to both present and future. So present stock and future stock. So subsection 2, a floating charge does not preclude the company from dealing with the assets of the company. So if you remember, in the case of in George Cohen, our own High Court was making the point, which suggests the freedom which the company has with respect to assets over which a floating charge has been created. And then in the case of Res Spectrum Plus, Law Scott also made the same point that when it comes to floating charge, the company has freedom in dealing with the assets of the company, which constitute the floating charge. And the company can continue to deal with those assets for as long as it wants until any of the following things have occurred, as specified in section 92 A to C. Until A, the security becomes enforceable and the holder of the security, pursuant to a power in their behalf in a debenture or the deed, securing same, appoints a receiver or manager or enters into possession of those assets. So we have already seen that a debenture is an agreement. So the agreement will specify, when the security will become enforceable. For example, it may be stated that where the company defaults in making payment of the agreed interest or repayment of a portion of the principal as agreed, and after 2 or 3 demand notices have been served, then the holder of that debenture, that the floating charge holder, can appoint someone who is a receiver or manager. So receiver means that he will go and take over assets of the company and collect proceeds which are being generated by those assets. So for example, if like the Mecom example, if you use like the stock in trade, right, as the floating charge, and let's suppose that the company has defaulted according to the terms of the agreement, it has become enforceable. So the debenture holder appoints a receiver to go and take over all the shops of Mecom around Ghana. And they'll be collecting all monies which are being paid. So the things being sold, they'll keep selling them, collecting the money. That is a receiver or manager. a manager will not only be interested in collecting the money, but he will also be interested in running the assets for it to continue to generate income. So, like the MECOM, when they take over, they not only be interested in selling the stocks there. As they sell and they raise money, they use some of the money to go and acquire and raise stock and things like that. And then they'll be taking like the profit margin, if you like, to pay off the debts owed to the debenture holder, at whose instance the receiver or the manager was appointed, as it were. Or instead of appointing a receiver or manager, depending upon the terms of the security or the debenture, the holder can enter into possession of those assets, physically take over of those assets. Or B, until the court appoints a receiver or manager of the assets on application of the holder. So the debenture holder at some point can go to court and ask the court to appoint a receiver or manager to take over assets of the company in respect of which the debenture relates. Or C, the company goes into liquidation where the company is not really going concern. The company is not able to pay assets and liabilities as they fall due. Liquidation may be triggered, and a liquidator will be appointed to collect and gather the assets of the company and use the proceeds to pay various creditors and claimants against the estate of the company. Now, when any of the things that we have talked about, occurs, when any of the things that we've talked about occurs, we say that there has been crystallization. So what is crystallization? So again, as I've told you, if you come across a word, you quickly go to the first schedule to find out, is there any explanation which has been given to that word that I have met? Now, if you go to the first schedule, there is no specific definition of crystallization. So the definition of crystallization that we have is what has been provided for us by a combined reading of section 90, subsection 2, and subsection 3. Because subsection 3 says that on the happening of an event, 3 events have been specified in the 2 above. The charge crystallizes and becomes a fixed equitable charge on those of the assets of the company that are subject to the charge. So therefore, crystallization refers to the events whose occurrence trigger enforcement of the floating charge, or events whose occurrence converts the floating charge to become a fixed equitable charge. So previously, the floating charge was just hovering. It was not actually linked to any particular assets. When crystallization occurs, it will no longer be hovering. It will now settle on particular assets. And because it has now settled on a particular asset, it has become a fixed equitable charge. And it will now be sharing some of the characteristics of a fixed charge. As for a fixed charge, right from its creation, it is referable to a particular asset of the company. In the case of floating charge, from its creation, we do not know, we have not ascertained yet which particular assets of the company it relates to. You only know particular cell of the company that relates to when there has been crystallization. And crystallization occurs when we have any of the three things that we have mentioned. One, either the security has become enforceable so that the debenture holder has appointed receiver or manager, or has even entered into possession of assets of the company to which the floating charge relates himself. Or the debenture holder has gone to court for the court to appoint a receiver or manager. And later on, we will see very soon that where the debenture holder is of the view that the assets over which the debenture, the floating charge is created, for example, is in jeopardy, it may go to court for the court to appoint a receiver or manager, as it were. Or when liquidation has been initiated against the company, then automatically the floating charge will convert to become fixed equitable charge. Because, when liquidation has been triggered, the normal operation of the company will change. The directors will not be able to deal with the assets of the company as it were, because a liquidator will have been appointed to take over all those things, whose duty it is to collect and gather assets that is available in order to pay those who may have provable claims against the company. But the point to note is that crystallization is reversible. That is to say that when crystallization occurs so that the floating charge becomes a fixed charge, it does not mean that it is forever or it is permanent. No. So if you look at section 90, subsection 4, where a receiver or manager is withdrawn with the consent of the chargee, or the chargee withdraws, that's the debenture holder, from possession before the charge has been fully discharged, the charge ceases to be a fixed charge and reverts to a floating charge. So look at it. The charge is undergoing some kind of, if you like, metamorphosis. The charge originally was floating charge, and for that matter, it did not relate to any immediately identifiable asset of the company, and say that this is the asset over which the charge has been created. Crystallization occurs in any of the three ways that we have already explored. And we are told that the floating charge then becomes fixed equitable charge. Now, following the appointment of the receiver or manager, maybe receiver or manager is appointed, which was the crystallization in this case, but then the chargee, the debenture holder, looks at things and becomes satisfied that I think the company is now in a good health, so I can leave it to continue to be operated as it was. So let me withdraw the receiver or the manager I cause to be appointed over the company. So where the receiver or manager is withdrawn from taking over the company or particular undertaking or assets of the company, we say that the floating charge, which became fixed equitable charge, revert to a floating charge. So look at it. It was originally floating charge. Crystallization occurs, so that became a fixed equitable charge. Now, the crystallization is, if you like, reverse as the receiver or the manager is withdrawn. So the crystallized floating charge, which have become fixed equitable charge, will go back to become the original floating charge, as it were. So let's keep that in mind. Now, 95, a fixed charge on a property has priority over a floating charge affecting that property unless the terms on which the floating charge was granted prohibited the company from granting a later charge having priority over the floating charge, and the person in whose favor that later charge was granted had actual notice of the prohibition at the time when the charge was granted to that person. Now, Section 95 is quite instructive on a number of points. So first, a fixed charge as a general rule has priority over a floating charge. And the rules and priority we are talking about here very soon, we'll look at the Corporate Insolvency and Restructuring Act 2020 Act 1015, and we'll look at what we mean by priority. No, by priority, we are talking about where, for example, the company is being liquidated. There are various, various people who have got claims against the company. So these claims, they have to be classified. And when the classification is done, then there have to be priority allocation to the various classes. So that is the point about the priority we are talking about here. But we are saying that before we even come to look at Section 107 of the Corporate Insolvency and Restructuring Act 2020 Act 1015, we have to remember that as a general rule, a fixed charge has a priority over floating charge. So that is the first principle. Now, there's an exception to that general rule, and that exception is this, that a floating charge might have been created, and under the terms of the creation of that floating charge, there was an express clause in it which prohibits the company from actually creating a fixed charge or any charge, like granting any charge which will have priority over the floating charge. And where the subsequent charge holder was aware of this express clause in the earlier floating charge created by the company, which prohibited or which forbids the company from creating any charge that will have priority over the original floating charge, then even if the subsequent charge holder had a fixed charge, that subsequent charge holder will not enjoy the priority which is ordinarily enjoyed by holders of fixed charge. So that is the point Section 95 is telling us. So there's what we call the negative pledge clause, as it were. And that is what is reflected in the Section 90 subsection 5. So let's keep that in mind. Let's look at the powers of the courts. See if the eraser will work from this one. Eraser. Jesus. Going. Anyway, let's continue without it. Yeah, so section 91 talks about the powers of the court. Where a fixed or floating charge becomes enforceable, the court may appoint a receiver. In the case of a floating charge, a receiver and manager of the assets subject to the charge. So let's look at it. In the case of a fixed charge, only a receiver is necessary. Why? Because we have a particular asset, and that asset, its value will have been known, and all that. The receiver can just take over that asset, go and have it sold, right? Have it sold so that money is realized from it and used to pay off whatever the debenture holder has against the company in terms of the debt. But for the floating charge, as we know, it may be over a class of assets, including even present and future stock. So you don't need only receiver. You need a manager as well. Because a receiver and manager, he will be able to actually play the role that the directors of the company were playing. Actually take over the assets, be running it in such a way that it will be able to generate revenue, which will be enough to satisfy the debt which the company owes the charge holder, at whose instance the receiver and manager was appointed. That is in the case of a floating charge. Now, 91(2), in the case of a floating charge, the court may, although the charge has not become enforceable, appoint a receiver or manager if satisfied that the security of the debenture is in jeopardy. So where there is that fear that the security, that is, whatever is used as a security for the debenture, is in what you call the state of jeopardy, the court can actually intervene and appoint a receiver or manager to go and take over the assets of the company. So the question is, what does it mean to say that the security of the debenture is in jeopardy? So section 91(3) tells us that the security of the debenture holder is in jeopardy if the court is satisfied that the events have occurred or about to occur, which render it unreasonable in the interest of the debenture holder that the company should retain power to dispose of its assets. So 91(3) is creating that window of opportunity to safeguard the interest of the charge holder. It may well be that according to the original terms of the debenture, it's not yet time for the debenture to be enforced. It's not yet time for redemption and all that. However, where there is evidence that the way and manner affairs of the company are being run, if the company is given a free hand, which is usually given to a company when it creates a floating charge because of the autonomy or freedom, which goes to a floating charge, it may be detrimental ultimately to the interest of the charge holder, because the company may even end up collapsing or getting its assets so dissipated that it may become an empty shell and may not have anything for the charge holder to lay hands on should the right come arrive for enforcement. And that is why the law says that, section 91(2) says that the court may appoint a receiver where it is suspected that the security is in jeopardy, and Section 91(3) has told that what it means to say that the security of the venture is in jeopardy. That is where looking at events, looking at happenings, how things are going on in the company, the court comes to the conclusion that it is unreasonable, having regard to the interests of the secured debenture holder, to allow the company to continue to deal with the assets of the company as if no one had security over them. Then the court will appoint a receiver to intervene. So let's keep that in mind. Now, Section 91(4) is quite direct, that a receiver or manager shall not be appointed as a means of enforcing debentures not secured by a charge. So when it comes to enforcement of debentures, certain remedies are context specific. If you are a naked debenture, what you call the a naked debenture, that is unsecured debenture, you cannot ask the court to appoint a receiver or manager because maybe the company has defaulted in honoring the agreed terms of payment. No. Receiver or manager can only be appointed where you are a secured debenture. So an unsecured debenture is not entitled to get a remedy of appointment of a receiver or manager. So let us keep that in mind. So let's look at the rules on payment of preferential creditors. And here, out of us a subject to future here, I would like to draw your attention to the fact that the Bodies Corporate Official Liquidation Act, which has been alluded to in Section 92, has been repealed. So in place of Section 41 of the Bodies Corporate Official Liquidation Act, 1963 at 180, you should cancel that in your law and rather write Section 107. Section 107 and Section 130. Section 107 and 130 of Corporate Insolvency and Restructuring Act 2020 at 1015. So let me see if I'm able to write it here for you. It's a minute. Okay. Yes, I wanted the writing to go. It's gone now. Yeah, so if we look at the Section 92, as I said, we need to cancel this. Let me show you. All this should go. That's what I mean. It should go. And in place of that, we have corporate insolvency Wait. Solvency. Restructuring. Seven, 15. Session 106. Especially. No, sorry, I said 107. 107, sorry. 107. And also session 130. Yeah, so please, the highlighted portion in section 92.1, as I said, has been repealed. And in this place, the relevant legislation, the Corporate Insolvency and Restructuring Act 2020, Act 1015, section 107 and section 130. So where a receiver is appointed on behalf of the holders of the debentures of the company secured by a floating charge or possession is taken by on behalf of those debenture holders of a property subject to the charge. The debts, which in the winding up are under no. So now we have section 107 and 130. In fact, 1015 to be paid in priority to any other debts shall be paid out of the assets coming to the hands of the receiver or any other person taking that possession in priority to a claim for principal or interest in respect of the debentures. Yeah, so we are being told that, yes, despite the fact that you are a floating charge holder, you are secured, no, debenture holder, that is true. But we know that when it comes to winding up of the company, when it comes to liquidation, there are certain preferential creditors, certain creditors who will be given preference or who will be given priority over others. So those preferential creditors who have priority over floating charge holders, where there has been appointment of a receiver, for example, on behalf of a debenture holder. What section 92 is saying is that monies realized by the receiver from assets that were subject to the floating charge, part of that money will be used to satisfy claims which will have been paid or settled in favor of certain preferential creditors if the company were to wind up, if the company was being liquidated. So that is what 92 is telling us. Now, where the receiver or any other person taking possession as provided for in subsection 1 makes a repayment in respect of the debenture before discharging the debts, having priority in accordance with subsection 1, the receiver or that person is personally liable to discharge the debt to the extent of the repayment made by a receiver or that person. So we are being told that, yes, despite the fact that a receiver has been appointed at the instance of a debenture holder according to any of the parameters that we have discussed, the receiver should still be mindful of the rules on preferential creditors, the rules on priority when it comes to liquidation or winding up, how certain classes of debts against the company are given priority over others. And if the receiver should ignore those preferential creditors who should have their claims paid first and go ahead just to pay that which is due to the floating charge holders, then that receiver or the particular floating charge holder who caused the appointment of the receiver will bear personal liability for monies which ought to have been paid to preferential creditors by reason of their preferred status. So let us keep that in mind. So if you look at subsection 3, we are being told that the periods of time mentioned in section 741 of the Bodies Corporate, of which is repealed. So in this case, section 107 and 130 shall be reckoned from the date of the appointment of the receiver or possession being taken. And the payment made under this section shall be recouped as far as may be out of the assets of the company available for payment of general creditors. So let's keep that in mind. Now, just before we move on, I would like to, of course, we go and look at the Corporate Insolvency and Restructuring Act 2020, which is very important and everybody should have a copy. I'm actually going to set a seminar for you, and it will be, I'm going to give you a group presentation, and I think it will be on the Corporate Insolvency and Restructuring Act, so that we're able to cover all the key areas of the syllabus before we end. But just for our present interest, section 107, which I have alluded to, that is section 107 of the Corporate Insolvency and Restructuring Act 2020 Act 1015, stipulates, and I quote, on the commencement of liquidation, the liquidator shall, in relation to each debt which runs for dividend, ascertain into which class the debt or a part of the debt falls. The 107.2 says, read, a debt shall be classified according to the ranking specified in subsection 3. And then subsection 3 provides a classification as follows, quote, a debt classified as A, class A debt, is a debt in respect of post-commencement financing, which takes priority over all other creditor claims, including secured and preferential class, and shall be paid in full. So we have been told that, yes, we have what we call the class A debt, and class A debt is even superior to all other creditors. And that will include secured and preferential class. Now, B, class B is a preferential debt which I ranks equally between other preferential debts against the estate of the company. So that is class B, the first part, or II, shall be paid in full unless the remainder of the estate is insufficient to meet the preferential debts, in which case the preferential debt shall be paid in equal proportions. And II is debt or part of a debt which answers to either of the following descriptions. AA, remuneration owed to an employee, so that is unpaid salaries of workers. BB, rate, taxes. So that is arrears or monies due to the state by reason of taxes. So all those are part of Class B debts. Then Class C debt. Class C debt is a secured debt and shall be secured by a fixed charge against an asset of the company. So if you look at the rules of priority, despite the fact that fixed charge as a general rule even ranks in priority to floating charge, if you look at the Corporate Insolvency Restructuring Act, fixed charge is a Class C debt, meaning that it is inferior to two other classes of debts already. Class D debt is a debt or part of a debt which does not fall within a Class C debt and is or was within the year preceding the commencement of the winding up owed to a director or former director of the company. And we have a Class E debt. And then we have Class F debt, Class G debt, Class H debt. Yes. So where receiver is appointed, these rules on priorities, that is the preferential creditors, according to their appropriate categories, will have to be respected. That is the point we're making under section 92. So let's keep that in mind. So we will draw the curtain down here, and then we continue our next class Saturday, unless there's a question. If you have a question, just raise up your hand and then we'll deal with it.